Is there a requisite blood quantum for relief under McGirt? I'm Tulsa attorney James Wirth, and we're talking about the requirement that there be a certain level of Indian blood in order to qualify for relief under the United States Supreme Court precedent in the McGirt case. All right, so we've got a lot of these McGirt cases that are going before the court. We've got a lot of prosecutors that are not wanting to dismiss these cases, that there's good argument that the state lacks subject matter jurisdiction over them. So they're coming up with a lot of arguments to try to stop that from happening. And one of them is to say is that there's got to be a certain level of Indian blood in order for them to qualify under McGirt. And the prosecutors that are making this argument, they are relying upon the case of Goforth, which is a case from the Oklahoma Court of Criminal Appeals in 1982. And what that case says is that there has to be a, quote, significant percentage of Indian blood in order to for the state to lack jurisdiction. But there's a lot of other cases that use different language, and it's interesting because the Goforth case says a significant percentage of Indian blood, but we also have the LaBeouf case that says a sufficient degree of Indian blood, and then we've got the Vilpando case that says a substantial amount of Indian blood, and then we've got the Diaz case that says some Indian blood. Okay, so prosecutors are going with the language that most favors them. That's the one from the Oklahoma Court of Criminal Appeals in 1982 that says that we need a significant percentage of Indian blood. And then for defendants that are requesting relief under McGirt that don't have a substantial amount of Indian blood, they are objecting to dismissal and saying the court does have jurisdiction because they don't have enough Indian blood. However, that decision they're relying upon is just from the Oklahoma Court of Criminal Appeals, whereas the LaBeouf case is the Ninth Circuit opinion, Federal Appellate Court. The Vilpando case is out of Wyoming. And then the most important case we have is United States v. Diaz. That is a 10th Circuit case. Oklahoma is in the 10th Circuit, so this is precedent, and it's from 2012. So it's both a higher court in terms of precedential value, and it is a more recent decision. So we see courts relying on Diaz, and we believe that the Oklahoma Court of Criminal Appeals, rather than going along with their prior language from 1982, is going to go along with the language that they've been given from the 10th Circuit and say that it just has to be some Indian blood. No particular quantity as long as there is some. However, that can still reduce by some amount the people that are entitled to relief, because we do have freemen who were members of the tribe granted membership after the Civil War that may not have any blood quantum. But we do believe at least we're going to have the court finding that any amount of Indian blood, as long as it can be proven, is enough to get relief under McGirt. There's going to be a little bit of question of how you determine the amount of Indian blood. The easiest way in order to get a accomplishment of a dismissal of a case or showing that the court has a lack of jurisdiction over a Native American is to show that they have a lineal ascendant who is on the Dawes rolls. And the Dawes rolls lists that person's percentage of Indian blood, and then that's divided just down by how many ascendants there are before you get to the defendant involved. So if you've got somebody who's on the Dawes roll that is your great grandfather that was 100%, then you half that, and then you half that, and you've got about a quarter. And that's the amount that's going to show on your CDIB card. So that's pretty clear cut. But what if you don't have that? Is it sufficient to do DNA testing? Those are issues that have to be decided. But as far as the question is there a requisite level of blood? I think the best theory right now is going to be that the Oklahoma Court of Criminal Appeals and other courts are going to go along with the Diaz decision and require at least some level of Indian blood, but not any quantifiable amount, just as long as it's some amount. Even if it's 1/28th or even less than that, as long as it is some amount listed that is likely to be found to be enough. If you're in a situation where you don't have proof of Indian blood or you're a freeman, then you're going to want to talk to somebody more specifically about your circumstances. If you want to talk to somebody at my office about that, you can do so by going to makelawEasy.com.